This video has been made to provide procedural guidance to lodging parties regarding the lodgement process for a grant application with the South Australian Probate Registry. This video is general in nature and does not provide specific guidance with respect to all types of applications. Court staff cannot provide legal advice. If you require legal advice concerning your application, you should speak to a lawyer who specialises in the area of wills and estates. This video is about what a grant and what a registrar certificate looks like as issued by the Supreme Court of South Australia. If you're lodging an application with the South Australian Probate Registry, then you already know you need a grant to be able to administer the assets of the estate. The grant is an electronic document which confirms who has authority to deal with the estate. The grant will have the seal of the Supreme Court in the top right-hand corner, the issue date, the probate number. Each file has a unique probate number assigned to it. The grant also has details of the deceased, their full name, last residential address, place of death, and date of death. The grant recites what type of grant has been issued. In this case, it's a grant of probate, meaning there is a will with an appointed executor. But we also issue grants of les administration with the will annexed, les administration, registration of interstate grants, and reseals of overseas grants. The grant recites details of who it has been issued to. In this case, because there is a will with an executor, it is therefore a grant of probate. If there had been more than one executor appointed under the will, they would all have their details listed underneath, with an explanation of why they're not acting. For example, whether they had died, had leave reserved, renounced, or were unable to act. These details are recited on the face of the grant so that if a third party looks at the grant, it should tell them all the pertinent details that they need to know about who the deceased was, what type of grant, and who's taken the grant, i.e. the legal personal representative. The third party, say if they're from the Land Services Office or if they're from the bank or a nursing home, then know who has authority to sign their relevant documents to administer the estate assets. The court does not seal and produce paper grants anymore, which is what this paragraph down the bottom of the grant is about. The court seals an electronic grant, and that is the original grant. Once issued, it becomes a public document and can be searched by anyone via Court SA. If there is a will, an exact copy of that will with the court seal on it sits behind the front page of the grant. Please be aware that when the original will is lodged with the probate registry, it is not returned. The last page of the grant is about the assets. It's saying that you, as the applicant, have told us about the assets. You've given us all of the details and you're saying that they are true and correct. The probate registry does not check the details of the assets. The registry does not go and call the Land Service Office, banks, nursing homes, share companies, etc. to double check that the details are correct. The onus is on the applicant to make sure that the application and details are in order. This is particularly important when it comes to the Registrar Certificate of Disclosure, which is the other document that you will receive when the grant is issued. Now, a Registrar's Certificate of Disclosure will have the seal of the court on it, the issue date, the probate number, and the name of the deceased. Then the details of the assets are recited. When you're typing in the asset information into your online application, it's incredibly important to make sure those details are correct. What you type in will be what is published on the certificate. So if you get the numbers wrong, such as the volume and folio number when disclosing real estate, or bank account numbers are incorrect, those organisations may not release the asset to you until you produce an amended version. This means that you'll have to come back to the probate registry to lodge an affidavit to amend the certificate. The certificate is confirmation that you've complied with Section 71 of the Succession Act 2023 SA and disclose the asset to the court as required under that section of legislation. Again, it's an electronic certificate. The registry no longer produces a paper certificate and both the grant and certificate come as PDF documents when issued, so you can print, email, download as you need to.